Welcome to Solvencies and Legal Encounters. All right, we have a pro se plaintiff and defendant going against each other because money's owed. Word of advice: before you pay for a trip for someone, make sure they have the ability to pay you back. Let's go.
So let's move to the next one. That's going to be CV 25000591. This is Amanda Bridge versus Bernadette Gasper. Do I have someone first for our plaintiff, Amanda Bridge?
Yes, that is me.
Good afternoon, Ms. Bridge. And do I have someone on behalf of the defendant, Bernadette Gasper?
Yes, Your Honor, that is me, Bernadette Gasper.
Good afternoon to you as well. All right, Ms. Gasper and Ms. Bridge, thank you both for being here. I'm going to ask if I can go ahead and just have both of you raise your right hands. I'm going to swear you both in. All right. Do you understand that by appearing in court and offering me testimony, you are swearing to tell the truth, the whole truth, and nothing but the truth under a penalty of perjury? Do you so swear?
I do.
I say fantastic. All right, thank you. All right. And Ms. Bridge, you have instituted the lawsuit. Ms. Gasper, I don't think we don't have a counterclaim though, right? This is just a single.
There was not a counterclaim submitted, no.
Just making sure. All right then. Real quick, I'll give both of you a bit of an overview. So Ms. Bridge, as the plaintiff, you'll always get to start and end the situation, right? So first you tell me why you've sued Ms. Gasper. If you're suing for money, tell me exactly how much money it is, right? That way because what I'm writing down is what is it you're trying to get and how do we get there? Ms. Gasper, as the defendant, you are literally allowed to say absolutely nothing for the entirety of Ms. Bridges' case. You're allowed to be completely silent until she says, "Judge, that's it." And then you're allowed to say any and all things back. Certainly, I'll give you each a chance to ask questions of the other. Given that you're just both solo, what's called developing the case, I may occasionally, and I hate to say, I might interrupt and be like, "Hey, let me ask you this," because I'm looking for very specific information. Okay? All right. All right, then. Ms. Bridge, why don't you tell me what this lawsuit's about?
Great. Good afternoon. I'm the plaintiff, Amanda Bridge, and I am seeking repayment for $2,919.17 from the defendant for costs she agreed to reimburse from a shared vacation from June to July in 2023. I have lots of evidence. I've submitted like a bunch of exhibits for you to reference. If that's not available to you, I'm happy to share my screen. But in addition to this $2,919.17, I am also seeking documented damages and statutory interests of $1,791.59, resulting from her failure to pay, as evidenced by exhibits B, C, and D.
I would love to see what those damages are for.
So really, I'm here to collect what is owed, which is $2,919.17, but total, including at your discretion damages, it would be $4,710.76. So here is my statement.
That's perfect. That's a great opening statement. Just real quick, Ms. Gasper, do you want to make a statement now or do you want to wait till the complete end of Ms. Bridges' case?
Sorry, that wasn't the end of my statement. That was just. No,
I apologize, Ms. Bridge. I thought that was the conclusion of your opening statement. Go ahead.
Cool. Okay, so from June 18th to July 2nd, 2023, the defendant and I traveled together to Ireland and Greece. I initially planned for her plane ticket up front on May 1st, as seen in Exhibit A5, and she agreed verbally that she would pay me back for it.
Okay, Ms. Bridge, you're actually getting into testimony, so that is not the same.
Okay. I don't understand.
I just want to know this. Ms. Gasper, you have the right to right now. She's suing you for a little over $4,000. You could right now say, "Judge, it's correct, but I already paid her back." Or you could say nothing, or you could make a statement. It's just your choice, Ms. Gasper. Would you like to make a statement now? And it's a short statement, or do you want to wait till the completely end?
Yeah, I would like to make a short statement if that's all right.
Yeah, absolutely.
So I am here today being sued by the plaintiff for the amount that she had mentioned, which includes a base claim of $2,919.17, which the plaintiff asserts that I owe her, in the additional amounts that she labels as damages and additional costs. To date, I have not been provided with an expense report that is including receipts to verify the accuracy of any of those amounts. Without full documentation, I can't verify any amounts that may or may not be owed.
Ms. Gasper, if I'm reading between the lines here, your defense is not that you don't owe her the money, but that she hasn't showed you owe her that much.
Not necessarily.
Question, Ms. Gasper, do you owe her money from the trip y'all took to Ireland and Greece? Yes or no?
I do owe her money
Great. So we're halfway where we need to go. How much do you agree you owe her?
I would believe it's somewhere in the base claim amount of the $2,900. However, she does additionally owe me money from that trip that she has not paid at all.
Now that's interesting.
And how much is that?
That I show is $752.17, which has been made in no partial or full payments.
So if I'm giving you full credit and taking it as true, you owe her $2,200.
Somewhere in that range, yes, Your Honor.
There's no dispute about that, right?
Mhm.
Okay, great. Look at that. We're already halfway there, y'all. All right. Ms. Bridge, what are the 1791 in damages?
The damages are, let me pull this up. So, on top of her debt, I've experienced significant stress that required professional support.
You don't get any of that.
Don't need that.
That may be true, but legally what you get for a breach of contract is actual damages. And then if you had a written agreement for interest, did you have a written agreement?
No.
Then what else is the 1791 from?
It is from filing fees
You
and
get that?
costs.
Because that's what that actual cost you had to spend to come to court. Okay, what else?
Legal costs.
How much did you incur for legal expenses?
$186, as well as my demand letter, which cost me $17.57. This demand letter included the receipts that the defendant has claimed she did not receive.
What was the 186?
186, these are in exhibits C1 through 4, and they are working with lawyers.
Okay, so 186 to the lawyer, 18 for your mail cost, your cost of court, and then 2,200?
No, it is $2,919.17.
I know. She's admitted she owes you 2,200. Right, like she just said, I know I owe her money. I think she owes me $750. So without fail, Ms. Gaspers acknowledged that she owes you $2,200.
This is not true. If you, in exhibit A0, you can see a complete breakdown of our splitwise costs.
Ms.
with
Bridge,
total-
Ms. Bridge,
Yes.
Ms. Bridge. Hey, listen and listen to me quickly.
Okay.
At the time y'all entered into the trip,
Mhm.
did you put in writing that you were lending her money and she was going to pay you back?
We agreed to it verbally.
In writing.
In splitwise, yes, that is in writing.
Where is that in your exhibits? Let me see the agreement to loan her money and she repay you. Because if it's in writing, you got a hell of a case. If it's not, you're getting $2,200.
Talk about getting to the point.
Yes.
And that's the reason. And Ms. Bridge, Ms. Gasper, there is a very important doctrine called the statute of frauds. If you can't pay someone back within a year, you have to put it in writing. So if you're telling me that she agreed to pay you back, I need to see it verbatim. Otherwise, I'm going to give you the 2,200, which she just admitted she owes you. And we are all good.
Yes. So exhibit E6 is her
Okay.
saying that she agreed to it.
And when
then
was that? Let's
that
see.
was July 18th, 2026.
Nope. We can't be
Or
2026.
sorry, 2023. My
Okay,
bad.
let's take a look. Let's take a look. So I'm looking at what is exhibits E1 through E10. I'm going to share my screen. All right.
And then
Ms.
also
Bridge, you said it was.
E14 also.
All right, so let's see. So here we are. Reminded debit to report expenses.
We are in E6.
Okay. All right, Ms. Gasper, when I'm looking, I'm sorry, Ms. Bridge, when I'm looking at this first one here, who is speaking in the black text on the left-hand side of the screenshot?
That is the defendant.
Okay, and who is speaking in the blue on the right-hand side?
That is me.
Ms. Gasper, is that correct? Can you see these? Are you the person speaking on the black on the left, and is the plaintiff the person in the blue on the right?
It does appear so, Your Honor.
All right, and I can see that these are screenshots that are from July 16th through July through 2023. All right, when did y'all leave on your trip?
We were there from June 18th to July 2nd, 2023.
So these are messages after y'all were already out and
Yes.
about.
Yes. So what exhibit
Let's see.
E6 is that we met in person. And then if you look at exhibit E7, which is next, you can see
Ms. Bridge, let me take a look at this one. You said this one says she promises to pay you back. So let me
This-
take a look here, because this one is July 18th at 9:51. Okay, so we actually are going left to right. I can read these as they appear. All right, judge changes to 8. Perfect. Hey, friend, do you want to meet somewhere for a drink or FaceTime? I can do a drink. Absolutely. What time? Let's go to Wanderlust. Okay. Headed to it. Sorry, headed out. Cool. Great. Made it home. None of this says she's paying you back on this page. So let's go to the next one.
So
This says
If-
she gave you money. That doesn't say she owes you anything.
yes, so what
How about this one? August.
So this is substantiating my claim that we made a plan to discuss repayment, which was set on July 18th. E4, if you go back up to E4, it says she met with her financial advisor, which then we met in person, and she met with her financial advisor to establish a repayment plan for me of $500 upfront and $200 a month until the debt was settled, and I agreed, which is evidenced in these two things. And so the repayment plan basically would take 15 and a half months from July 18th.
Ms. Bridge, I don't see that anywhere here. I'm looking at just this, right? Because this is the historical record. I know you're strapped for money. Can you give me some insight into Splitwise?
Yes, that is an
What has been causing you anxiety? I see nothing in here that says $500 per month going forward.
yes. If you okay. Sorry, I had a whole statement prepared that walks you through the evidence.
I just need a written record, a historic record where she says, I will pay you back a certain amount of money. She has admitted in court today to 2,200.
Okay,
You're
go to
saying the
A0.
remaining 700.
Okay, great.
But
Let's
in
go to
order to do that, you have to show me that y'all agreed in writing with specific terms and conditions. This is just y'all talking.
Even in courts like this, an attorney is needed.
yeah, go to A0.
Okay, let's take a look. Is that Exhibit A, trip receipts?
Yes.
All right, is this Exhibit A0?
Yes. So these are all the required.
Who created this document?
Splitwise, the app, and then I printed it.
Okay. And what is Splitwise?
Splitwise is an app that allows you to input costs and expenses, and then what it does is it automatically settles it. And so what the defendant is claiming is what I owe her less what she owes me less what I owe her. So the $2,300 is basically the 29,000 or 2,900 whatever subtracted from what I owe her. And so in Exhibit A, I've labeled 1, 2 through 20 each of my receipts, which the defendant has received in the demand letter. And this is our documented split of costs that we have been withhold
So when I look at the bottom here, it says 2292.
Yes. So what it does is it automatically subtracts what I owe her from what she owes me.
This
And
doesn't
so-
prove she owes you 2,900. This proves she owes you 22.
Yeah. So if you just look at my costs, which I've highlighted, those costs add up to $2,919.17. And then the ones that are not highlighted are things that I owe her, which I have not received receipts.
Ms. Bridge, Ms. Gasper, as I look at this, it is literally split. And each of you at the bottom of these columns, which are labeled Amanda, and Bernadette, right? Y'all have the same amount. She's admitted she owes you the 2,200. I'm looking for proof that she agreed to pay you more than that.
So it's like, so if you look at this, it says, for example, line 1. So it's
Drinking in public, $134. Y'all each agreed to split it, $67 each.
but then it'll add, like, for example, $10 TV, phone, internet, $10. And so from that, it'll say subtracted, like,
And again, Ms. Bridge, you've got a case you're winning right now. I'm going to give you $2,200. If you want the other set in, it is necessary for you to show me an agreement where she says, I will pay you back $2,900 by this date.
And the way it's looking right now, we're not going to see that.
Well, I will make payments of these amounts. What you've shown me is a very loose agreement that took place in advance and what she's just admitted to owing you, but I don't see the additional $700. I got you covered. $2,200, you're winning that plus your cost court. You're solid.
I'm saying that she can claim all of her costs, but right now I'm giving her $700 that she has not provided receipts for. I have provided receipts for all $2,919.17, and if it's the $2,200, it's giving her $700 off of what she owes me.
That's right. But Ms. Bridge, I wouldn't give you anything if she hadn't admitted it today because you don't have an agreement in writing for her to pay you back.
I have it in person. We agreed.
I know that. But what I'm saying, Ms. Bridge, is that morally, friendship-wise, responsibly, she may have said that. Legally, for me to be able in court today to give you a judgment for that, you had to have put it in writing within the first 12 months. You can't change that after the fact.
Okay.
It's not that I don't believe you or that I wouldn't understand. Legally, I can't. She admitted in her opening statement that she owes you $2,200. We're good. You've won. I can't award you the extra money if you don't have a historical record that she promised to pay it back in 2023.
Okay.
Okay?
We don't need to do the additional 17,000 or 1,791.59.
I can't give you that anyway.
Fine. But if you, in Exhibit 0, if you total everything that the defendant owes me,
it's $2,292.
No, that's less what I owe her, which she has not provided receipts for.
Ms. Bridge.
Here it comes.
Again, your receipts aren't proving your case. The reason I'm giving you an award today is because Ms. Gasper literally said in court, I owe her the money.
Mm-hmm.
If she had not said that, you would have received nothing from me today.
Okay.
Okay? You absolutely can look into appealing my decision for the remainder of the money, but please go and look into the law about contracts. Because the thing that I'm saying is that you would have received nothing but for Ms. Gasper admitting she owed you $2,200.
Okay.
Okay. Judgment for the plaintiff, $2,200 plus your cost of court.
Great.
Your Honor, I did want to ask really quickly. I realized reviewing my notes throughout this case that there are $200 that were not accounted for that the plaintiff did not mention that I have paid her since the lawsuit has been filed. That need to be tacked on to the $752.17 that I had mentioned in my opening statement.
That's false.
Y'all, judgment for the plaintiff, $2,200 plus cost. Y'all can both appeal that. All right. Did y'all have a nice time?
Super.
No, I'm sincere. I understand it's not nice now, but traveling Europe is an amazing opportunity. Did you enjoy yourself?
I did, Your Honor.
Yeah. I want y'all to look back on your photos and not go, ugh, and have that be just a horrible situation. I know money is not a fun thing, right? But you got an opportunity to get out of the country? That's great. Very, very few young adults ever leave the state, let alone get to another place. So kudos on that, y'all. All right. All right. All parties are excused. Thank you very much.
Thank you.
I'm wondering how that went on so long and how do they both owe each other money? I don't get it. I wish it could have been more details in this case, but it was a good little drama session. So I hope you enjoyed that. So now we're ready to go into another case that you requested because we had our live stream with the pro se defendant that went to trial by himself. Mr. Nails is back. So we're going to go into that courtroom again in Judge Webster's court because he was eating in court. Now let's see what his trial's about. Since you asked, now you got it. Let's go.
And then Mr. Regier, is there any other order you want to take the remainder of the cases up?
Your Honor, the state is aware of one final matter on this docket.
And that is Craig Nails.
That is the state's information, Your Honor.
We are on the record now in BU 2024 TR 3419, State of Kansas versus Craig J. Nails, Jared Regier for the state. And sir, you are Craig J. Nails? Sir, are you Craig J. Nails?
Yes, I am.
All right. And Mr. Nails, we are set today for a bench trial on count 1, speeding 108 in a 75-mile-per-hour zone, and unsafe turning or stopping, failure to give proper signal in Butler County on December 25th of 2024. We have, as I said, set this for trial. Are you wanting to proceed with your right to trial today, sir?
No, Your Honor. I'm asking for a continuance. I'm doing family court here. I'm already late for it, actually. I've sat through the 2 hours here, listening to everybody else's. If Mr. Regier here is not opposed to it, I'd like to return to court November 5th, if that's possible.
Where did you get that November 5th date? Is that something that someone gave you as an that we might have open?
No, ma'am. It's just a suggestion.
All right. I don't know, Destiny, if that's a Wednesday trial docket, but do we have 11/5 open at 1:30?
No, Your Honor, we have November 19th.
Okay. And I only asked her that at this point because I didn't know if it affected what you were proposing, Mr. Nails. November 19th at 1:30 would be your trial date if I grant the continuance.
Okay, Your Honor.
Mr. Regier, do you object to this continuance or are you okay with it?
The state would so object, Your Honor. This would appear to be at least the third setting before this court. I am not aware of any obligations that the defendant might or might not have in other jurisdictions, so I cannot speak to that. However, the state has issued its subpoena. In fact, the state has issued 2 subpoenas in this case. It would appear that the state's witness is prepared to testify and the state is eager to reach a resolution in this matter. This is a case that is beginning to get a significant amount of age to it. The ticket in this matter appears to refer to a stop occurring almost 9 months ago. If the court does continue this matter, we will be very fast. We'll be quickly approaching the 1-year anniversary of this case. And so for all those reasons, the state would object to a continuance.
Mr. Nails' first appearance was April 30th, 2025. He entered his plea of not guilty, wanted to speak to the county attorney about more plea negotiations. And the state at that time agreed to dismiss count 2 for plea to count 1. The defendant still wishes to discuss further. And so the case was set over to June 25th at 1:30. I show a docket entry June 4th at 25 that the county attorney dismissed count 2. So an order will need to be filed addressing the fines, and the order will have the language to remove the fine for count 2. And count 2 was the unsafe turning or stopping failure to give proper signal. So that leaves us for trial today just on the speeding, correct, Mr. Regier? Is that the way you interpret it?
That would appear to be an accurate reflection of the June 3rd, 2025 amended information, Your Honor.
Your Honor, our last court date, the state's witness wasn't available at the time, and we got continued.
Excuse me, let me stop right there and then you finish here in a minute. I do show we were here June 25th, 2025, set for trial. And the defendant was present by Zoom. It's not clear in the docket notes who asked for the continuance. It is clear that it was granted until today. And so now, Mr. Nails, you're saying it was the the state that asked for that continuance because of, go ahead, please.
Yes, because their witness wasn't available. I asked for dismissal at the time, but we got continued to this time. Now, unfortunately, here now, I have family court.
Well, when you set your family court, did you tell them you had a bench trial set today?
No, I didn't. I know I didn't, Your Honor. And actually, I was pressed for time, believing that this would be a short time that we spent together today, and I would be able to continue on to this. But apparently, I didn't expect that I would sit through a lengthy trial and a lawyer's 2 other cases before that, actually 3 other cases before that.
Right, you were set on a docket, and that's what a docket means, number of cases, and we'll just go through them until we get them all resolved. And you just happened to draw the last one in the file. If you told me or anyone at the beginning of the docket that you had this conflict, we probably would have called you first. Likewise, if you told your family court that you had this case, they probably would have put you on a different date. But I think Mr. Regier, he raises a good point. You asked for continuance and it was granted, and I think you both, if one of you gets to ask for continuance, you ought to both get one. So I don't really want to do this to Master Trooper Cole, but it may have been his scheduling that we accommodated last time. So I am going to grant the continuance. That'll be the last one each of you get, unless you have some really strong reason. And when's our next available date, Destiny?
November 19th at 1:30.
November 19th at 1:30. I'm gonna start with you, Trooper. Are you available November 19th? If you know, that's getting close to Thanksgiving and family commitments. And I'm a big believer in family before a lot of other things, because family's what keeps us grounded.
Let me just check 1 second, Your Honor.
Okay.
November 19th, it appears I'll be available.
Mhm. And I understand in a trooper's life, that's subject to not getting an emergency call at the last minute and so forth.
Yes, Your Honor.
All right. And Mr. Regier, will you be available at that time?
The state will be still available, although the state will be requesting a ruling as to whether this continuance is to be assessed against the defense.
I will note that the state did object to this continuance and that it is solely at the request of the defendant. So any speedy trial issues would go towards the defendant on this continuance. All right. And so I'm going to expect everybody back here by Zoom, November 19th at 1:30. Don't make any other commitments. I'm talking mainly to you, Mr. Nails. If somebody tries to set another court hearing in front of mine, you tell them about this case. Tell them I can't do that. I've got another commitment.
Your Honor.
Yes.
I want to remind the court that the first time I came to court, I actually showed up in Kansas for a date that was listed on the ticket. They said that, hey, we couldn't do that. That I had to do something else. Okay. So then we had to go to Zoom. I showed this. Throughout the whole time, I've been cooperative with the court in every fashion possible. Even Mr. Regier here says we don't amend traffic violations. Hey, not less than 2 hours ago, I just heard Mr. Regier amend a traffic violation. I'm not understanding this here, but hey, as I'm going to point out, I've been fair throughout this whole process. I've hidden nothing. I've showed up on time. I've even been respectful to the officer at the time of the stop. I'm not understanding what prejudice there might be here on my part.
Oh, I see Mr. Knowles trying to hammer down on the defense.
Well, you were charged with speeding 108 and a 75 and failing to maintain a safe, I'm sorry, count 2 is unsafe turning or stopping, failing to give proper signal. And Mr. Regier has dismissed, as I recall, count 2. So we were only set for trial on 108 out of 75. So you've gotten the benefit of one of your charges dismissed. Maybe it should have been dismissed. Maybe it was done just out of, I don't know, kindness. I don't know, maybe out of appreciation because you have been courteous. But for whatever reason, you've had 2 cases down. This court thinks 108 is way too fast, even in a 75. This case is getting old. It was issued December 25th, Christmas of 2024, which is coming up on 2 years. We're allowing you to appear by Zoom. Yes, you were to call in on the first one, and instead you came in, and I appreciate that. But if you'd called in, they could have told you that Zoom was an option. And so I'm going to
first one, Your Honor, we didn't even have a court. They didn't even let me appear in court.
All right. Well, I'm trying to appreciate, sir, that you have been respectful and that you have been inconvenienced. However, I would remind you that if these allegations are true, you have no one to look at but yourself.
Yes, ma'am.
I didn't go out looking for you. The trooper was out just doing his job and And Mr. Regier didn't go looking for you.
Yes, ma'am. I agree with you.
So we're going to set this over at your request to November 19th at 1:30, provided nobody has anything already previously set. It will be by Zoom. Both sides now have had one continuance for good cause shown on each side. Hopefully no one's going to need to ask for another continuance. I understand life has events that happen and we have to deal with those, but hopefully nothing for either side between now and that date. Time will count towards the defendant because it's whoever asked for the continuance. Anything else from the state, Mr. Regier?
Not from the state, Your Honor.
All right. Anything further, Mr. Nails, or if we?
Knowles, ma'am, and
Nails
no,
or
there isn't.
Knowles? Am I pronouncing that wrong? That's Knowles, isn't it?
Yes, ma'am.
I'm sorry, I've been calling you the wrong name this whole time.
It's okay. I'm pretty accustomed to it by now.
Yeah, I know how those strange, they're not strange names, they're just unusual to most people. I know how those get mixed up and it's never fun when they do. But I'll try to remember that next time, but that's an L there, not an I. Okay, if there's nothing further then, Mr. Knowles is excused. Master Trooper Cole is excused. Prosecutor Regier is excused. Court Security 3 and Clerk Destiny, thank you all very much for your participation and assistance today. Anything else?
The state would thank Master Trooper Cole for honoring his subpoena here this afternoon.
Thank you very much.
Okay. All right, we are adjourned. This docket is over. And the next one will be a docket too, Mr. Knowles.
Well, Mr. Knowles was able to talk himself into another hearing. And also, if he would have been caught eating, I'm sure he wouldn't have got that next date. Tell me how you think this case went. Do you think he defended himself well? Or do you think the judge shouldn't have let him have another date? But I was thinking that he was sitting in there for a long time because we watched the trial that he had to sit through on the live stream, so it did put him behind. But I want to hear your opinion on it. So I hope you enjoyed the videos. Give it a thumbs up if you did, and I'll see you around on the next one.